Welcome back. We're into another year. Subject for today is largely infringement, which frankly I think is a subject that only a patent attorney could love, and I'm assuming that most of you don't want to be patent attorneys. But the fact of the matter is that if you're a startup or even an established company, you really want to avoid infringement, and particularly infringement litigation. Litigation is expensive, as we saw slides a few weeks ago basically showed. It easily can cost millions of dollars just in lawyers' fees. It's time consuming. District court proceedings plus appeals take years to complete, and they will require a lot of time from important people to your company who rather and should be doing other things. And perhaps worst of all, it's entirely uncertain what the result might be. So my goal over the next hour or so is to try to give you some understanding of what might happen if you're unfortunate enough to get into litigation, what the possible outcomes might be, and looking at it in terms of a startup company with its own patents, when you might be wasting your time and money if you sue someone else. You can't do much to prevent people from suing you other than what we talked about at the very beginning on looking very hard at how do you avoid being noticed and really making somebody unhappy about what you're doing. But you have a wide open choice as to whether or not you want to bring a suit yourself. We're going to see a lot of sections from the statute today, because I don't really know any other way to talk about or have background as what is or is not infringement. The basic patent law tells you what the patent gives you. It's just this right to exclude. And probably the most important thing to remember for you, and frankly a lot of people you will be working with, either as customers, suppliers, etc., is they don't understand that. They seem to think that a patent gives you the right to do something, which is unfortunately, as we talked about before, not the case. The Patent Act spells out 6 types of acts that infringe. They're in 271, A through C and E through G. It's a fair question. What in heaven's name happened to 271D? Well, the answer is A through C and D were in the Act when it was passed in 1952, at which time there was a lot of discussion as to whether a patentee could lose its rights to infringe if it did various things that, were it not a patent owner, might be deemed contributory infringement. That's all now passé law. E through G have been added since. How long does this right to exclude last? I've said this before. It's usually from the day a patent issues until 20 years from the date on which the earliest priority application, the one you're saying patent supports as this drives a stake into the ground is what's prior art, was filed. I think I may have mentioned that there are times in which the term may be extended for more than 20 years. The 2 principal ones are if Patent Office frankly has delayed an examination in such a way that it's taken more than about 3 years, or if you're in a biotech industry, you spend years with the FDA trying to get approval. Infringement means patent claims. Claims and not patents are all that's infringed. A claim, as we've seen, typically has an awful lot of separate elements of a system, parts of a system, or steps of a process in it. To literally infringe a claim, everything in that claim has to be in the accused so-called infringing product or device. It's important to remember that your patent, or anybody's patent, describes or illustrates a lot of things beyond what's in the claims. Claims rarely cover everything a patent discloses. A lot of what's disclosed in a patent is necessarily background, prior, and frankly old. Beyond that, the claims are nearly always cut back in scope while you're trying to get your patent out of the patent office. On the other side of the coin, claims themselves are rarely limited to exactly what the patent describes. There may be quite obvious variations on how you might do things. If, for example, your patent describes holding two boards together with a nail, there obviously you could hold those two boards together with glue, a screw, or a clamp. Also, a patent doesn't cover later improvements. You have to question what it's really worth. If all your patent covers is a very rudimentary engine, isn't it important commercially, and it's important legally, and it's the fact that your claims can also cover a much more modern device, so long as that device actually uses the, quote, invention, close quote, that the patent talked about. What the words of a claim mean is critically important. A patent office examiner and a court don't construe claims the same way. The examiner will follow a patent office rule that a claim should be given what's called its broadest reasonable interpretation. You can amend claims over in the patent office to make them clearer, and the examiner will force you to do so. A court, on the other hand, is stuck with the patent as issued. The claims can't now be changed, so it has to look at it in a slightly different way. It looks at it as, okay, how would somebody working in this field, what would they think if they read the whole patent and they read the history in the patent office and how you got it? What would they think these words mean? Let's look at this chair at the bottom that you've seen before and look at a claim. Let's say the claim calls for a chair that has a firm surface, a fixed distance above the ground. If you're the patentee, what do you want firm to mean? Do you want it to mean a flat board, absolutely unyielding? Or do you want to mean that it's only fixed in place and doesn't shake or tremble? You'll find all those different definitions if you go to dictionary.com. What about fixed? Does it really mean only one place? Or does it mean, perhaps more broadly, what if it's not readily movable, but it nonetheless can be put into a number of different positions? If firm means hard, unyielding, or fixed means you can't move it, claim doesn't cover that chair. If, on the other hand, it means only that the chair doesn't shake or tremble, assuming the base is decent, firm, it does cover it. And if it covers fixed means you can fix it in a number of different positions, it would cover that too. You as a patent owner would want one type of definition. Somebody who is trying to figure out how to compete with you would want another. And who are these people who might be trying to compete with you and you might want to look at and perhaps even sue for infringement? Are they manufacturers, or are they only customers or end users? If they're only customers or end users, are they also potentially your customers or end users? Because it's usually not a good idea to sue your own customer. If your patent is for a multi-piece product or a method that obviously includes a lot of steps, does a single person practice every single step or use every component? If not, there can be problems. Can you actually prove that your claims, as they're written in the patent, are infringed? Or do you have to have a lot of knowledge about what is really a competitor's computer code, about what happened in its factory when it made its product, and whether all the characteristics of some product are really there? How do you prove this? And particularly, how do you prove it before you sue? Because the rules, at least in this country, are fairly clear that unless you've got really decent proof that a product is infringed, you can't bring your lawsuit or you're subject yourself to damages for being unreasonable. As I just indicated, literal infringement means that everything in the claim is part of the accused device. Once you've construed the claim, you decide what firm and fixed means, you then look at that chair and say, okay, here's what the claim says, here's what the chair has, write down the list, and if everything is there, you're fine. But what if something isn't there? That normally means there's no literal infringement, because as I said a minute ago, you have to have everything in the claim. But if something isn't there, is there some substitute? Is there some substitute that does essentially the same thing that the part that was left out or the step that was left out did and serves essentially the same purpose? If so, there can be infringement under what's called the doctrine of equivalence. You've got the equivalent of what is claimed in the infringing product, and you're permitted to say, to prevent a fraud on the patent, to prevent a rather simple and often case what should be in retrospect stupid change, to avoid infringing what is really a substantial step forward. The problem here is there's a tension. Who should bear the burden on making sure that a claim literally says what it covers? From the public's point of view, you want to be able to read a claim and know whether you're potentially in trouble. From the patentee's point of view, you want all the leeway you can get. Doctrine of equivalence, when it's applied, puts much more of the burden onto the public than the patentee. And here's an example. This is from an actual case, believe it or not, one that went on for almost 20 years and I was involved in for about 15 of those. The device that's shown there on the right is what's called a rodless cylinder. It's got a piston inside it and it's got a sleeve around it. And what it's supposed to do is, if you move the inside piston, the sleeve will move along with it, so you don't have to have a piston rod sticking out of one end, and simply by putting hydraulic fluid at high pressure in one end or the other, you can make things go back and forth. Simple product, they've been around for quite a while. The company in Japan wanted to make a product that competed with the product owned by the patent, made by the patent owner. It also didn't want to get into an infringement fight. So it looked at the claim, and it noticed that the claim says that that sleeve around the outside that goes back and forth has to be made of a magnetizable material. Claim also says that the sealing ring has to have, that inside at each end of the piston, there has to be both a sealing ring and a guide ring. The guide ring prevents the piston from canting as it goes back and forth and scarring up or not moving, getting hung up. But you don't need two sealing rings to prevent fluid from moving through. You only need one. So what did the Japanese company do? It made the sleeve of a non-magnetizable material, aluminum, because it realized the magnets themselves on the inside of the sleeve and on the outside of the piston will provide all the coupling that you need. And it got rid of one of the sealing rings. It got all kinds of opinions that said, you avoid this, you don't have two elements of the claim, you don't literally infringe. Patent owner, as you might guess, didn't agree. It sued under the doctrine of equivalence and said that since you didn't need a magnetizable sleeve, a non-magnetizable sleeve was equivalent, and since you didn't need two sealing rings, one with only one ring was equivalent. And a lot of courts agreed for most of the 15 to 20 years that this case was going on. Fortunately, since we represented the Japanese company, we eventually won. And it had to go all the way to the Supreme Court. Actually, went up there twice before we won. Why? Because the requirement for two rings and for a non-magnetizable sleeve had been added to the claim during prosecution. And if you're trying to get a claim, you'll often add things. But there's a price if you do so. Anything that you've added, you're literally bound by. You can't ask for equivalence. Because added that there were 2 rings, you can't say that one's the equivalent of 2. Had you not added it, had it been in the original claim, you can make that argument. And as the litigation that went on for most of these years showed, a lot of judges and juries will agree with you. So one of the things, if you're looking at a claim of yours to decide whether or not you want to sue on it, or if somebody has threatened to sue you, first look, are you literally infringing? If so, you're in trouble. Second look, if not, can you sue or can you be sued because the changes that you made aren't substantial enough? The basic statute, as I said a couple of minutes ago, really has 6 sections of what acts are bad, and they're divided into 2 groups. The ones up here have been around in words since '52 and substantively long before that. A is really directed at the person who really makes, sells, etc., the entire invention. But what about B and C? They are directed at someone who doesn't make, use, or sell everything, but is really responsible for the fact that somebody downstream does use a device or practice a method that has everything in it. It's going after the person who is really responsible. Something I've used and talked to people in classes before it's something akin to a bank robbery. People who walked in with a gun are clearly the robbers. But you didn't walk into the bank, and you didn't drive, and all you did was drive the getaway car. You didn't plan the robbery. Are you responsible? It all depends, and it really all depends. In some cases, you might be, if nonetheless you were the person who really directed everything. But on the other hand, if you weren't, should the cab driver be responsible for driving the bank robbers away? This also, B and C, make it possible to sue somebody other than the downstream customer. And you don't want to do that not only because it might be your customer too, but also because the recovery from any single customer is going to be pretty small. On the other hand, if you can go back up the chain to the person who really was responsible for all of this, there's typically a lot more money involved. Key takeaway here to remember, and I probably mentioned it sometime over the past few months, is direct infringement is a strict liability provision. If you don't have to have any knowledge of the patent at all for somebody to come in and say you directly infringe, and if they're right, to prove that you do, and you're responsible, you can be completely innocent in your heart and liable in the lawsuit. Doesn't require any knowledge. On the other hand, if your customer puts together or practices, you may not be liable under A. Your customer will be the direct infringer, so it will be liable. So then where do we go from there? One major question in all of this is, what do you do if you have a patent in which the method has half a dozen steps, or the system has 2 really very distinct subsystems? Suppose one person does half the steps and another does the other half. Suppose one person owns half the machine and he simply sends over the internet information to somebody else who owns the other half of the system. Is there an infringer? Who did everything? The answer is nobody. And there may be no infringement at all because of the way the Federal Circuit has interpreted this statute, unless somebody can prove that one of these 2 people was really responsible for doing everything and directed everything, or they work so closely together that they might as well have been. Second subject. Let's think about a razor. Patent is on the razor and the blade, and the two snap together. Blade wears out. Can you replace the blade without infringing? Fortunately, the answer with a proviso is no, you can't. Because, as the Supreme Court has held, simply replacing individual parts, either one at a time or frankly, as you work your way through a complicated machine, practically everything over time, is simply to repair what you already bought from the patentee, and the patentee can't prohibit you from doing so. There's obviously a line as when does repair that you can do turn into infringement, and the answer is, when you really reconstructed the original product, but it's very unclear exactly what reconstruction means. There's a case out of the Supreme Court now probably 40 years ago where somebody had bought some old rusted machines for making 3-ounce cans of tuna fish. Somebody else bought those machines, threw away practically all the parts, a few were left, but reconfigured everything so it now made 6-ounce cans of tuna fish. Is that reconstruction or is that repair? The Supreme Court held that was permitted repair. A proviso here, does it matter who made the original product? And the answer is a very strong yes. The right to repair is limited to something you got from the patentee or from one of his licensees. If you bought an infringing device to begin with, anytime you repair it, you're probably liable for directly infringing for actually making the product. Components, consumables are extremely important. There typically are an awful lot of the profit that a patentee expects. Gillette wants to make a lot of money off razor blades that fit its razors. How many people want to make money off ink for an inkjet printer or paper that's used in it? What about light bulbs that go into a product? So let's turn the page to indirect infringement. When are you responsible even though, oh no, I didn't do this, somebody else did it? Well, there are two real parts. First thing to remember about them is that although direct infringement doesn't require any knowledge, even for the person who made and sold everything to begin with, indirect infringement does. Congress made the policy decision that somebody who doesn't directly infringe cannot be legally responsible for what happens downstream unless they knew about the patent and really intended to have somebody downstream infringe it. The simple case is that the product I sell is what in God's name are you going to do for it but put it into an infringing machine? And there are an awful lot of those products around. If you're selling computer chips, people don't use them as paperweights. They put them into computers. It's the only thing it's good for. If, on the other hand, you're selling nails, there are an awful lot of things those nails might be used for in things that have utterly nothing to do with the patent. The intent in C comes from this doesn't have anything else to do. In B, which requires that you, quote, actively induce an infringement to be liable, it's a little harder to prove. The seller there doesn't have to have sold anything. Frankly, he doesn't have to be a seller. But he has to take an active part somehow in what's going on downstream where the full infringement is taking place. The second group of provisions in the 271 are all relatively new. They've all come about since 1952, and a lot of them considerably since 1952. Depending on your business, these may be important. Each of them was intended to resolve a specific problem. Commercially, the most important is 271E that deals basically with drugs and biotech. And it's largely it's a long, complicated section. The part I put up here is only a small part of it. But fundamentally, it's a compromise. And it tries to balance the fact that the FDA may not approve a drug for a long, long time after a patent is issued, and the patent may be close to expiration by the time even you can sell it. And it also wanted to make sure that once a patent did expire, there could be reasonable competition within a relatively short period of time. So they came up with this compromise. The first thing they did was to extend the term of the patent to make up for the time it had been sitting before the FDA. That's the last of these sections, 156. The other two things it did was it gave, in E1, it gave a generic or somebody who wants to, frankly, make essentially the same drug, the ability to do the background work, to do all the testing work, the trials, etc., before the patent expired by saying that this background preparatory work isn't infringement if what you're doing is simply trying to develop the information so eventually you can file something with the FDA. And the other thing it did, and that's E2, was to recognize that the FDA can't approve a third-party application for a patented drug until the patent expires. And that can be a long time. So it made it possible for the generic to accelerate the process. If the generic could now file an application for a drug that was claimed in a patent, and that would be treated as an act of infringement. Nothing had been made yet, nothing had been sold yet, but because it's an act of infringement, now the patentee could sue for infringement. And there's a whole garden group of patent attorneys who have grown up making their profits on nothing more than this type of what's called Orange Book infringement. But it can be decided early. The patentee doesn't have to wait for somebody to eventually get in late. But on the other hand, the generic can try to get the issue decided before it's spent the time and often hundreds of millions of dollars that are necessary to develop the product in the first place. The second two of these sections these new ones deal with foreign manufacture and foreign sales. It's not at all unusual for people to make components of patented inventions in the U.S. and ship them overseas and let some overseas manufacturer supply the rest. Example, it was a U.S. company that made, we love shrimp in some reason in these cases, machines to can shrimp. They were complicated machines. And there was a patent in the U.S. that covered the machine, and it probably listed a dozen, I haven't gone back recently to look, different pieces of the machine. The U.S. company was smart. It never assembled the entire machine in the United States. And because it didn't, there was no direct infringement. So it sent the machines to Brazil with a letter that said, you know, it's going to be easy for you to assemble this. We're sorry we didn't do so earlier, but if we did, we'd have a potential patent problem. Supreme Court held there was no infringement because the whole machine hadn't been made in the U.S. Congress said, you know, this isn't particularly fair. And there was an earlier case that involved radios with tubes, and the tubes were sent separately from the radio. So Congress passed these two sections, basically saying that if you supply the types of things that would have been contributory infringement under B and C to somebody overseas, guess what? You're not going to get away with it. It's important to recognize that there are a couple of important limitations to this. It doesn't really apply as broadly as a lot of patentees would like it to. First, It doesn't cover components, chemicals, or anything else that are sent abroad to practice a method. It's directed only to product patents. Second, even if you've got a patent, what you send abroad has to be actually used in the final product that's sold. Microsoft found this out unpleasantly, or actually quite pleasantly. Microsoft sent Word and all of its Windows software abroad, either on what it referred to as the golden disk or wirelessly. When it's sent across the disk, because that's a simple example, those disks were never used in the computers that the European manufacturers sold. Rather, all they did was make copies from the disks and use the copies in the machines. Supreme Court said no infringement. This statute is limited to the actual component that's used in the machine, not simply used to copy so some other component can be used. The other problem involves U.S. sales of products made abroad, something that has obviously gotten much, much more important as particularly in manufacture in the Far East. What's the problem? Well, if there's no U.S. patent on the product, but only a patent on how do you make it, if the product's made abroad, it's not made in the U.S., and there's no direct infringement of that making the invention using the patented method. On the other hand, neither the product nor the process may be patented in some country abroad, so it can quite easily be made there. Before this amendment, there was a provision in the Trade Act that let the International Trade Commission bar importation of something that had been made abroad using a patented or a process patented in the U.S., but they couldn't grant an injunction and they couldn't award damages. All they could do is say, oh, you can't bring this product into the U.S., but if the product made it here, there was no injunction and no way to recover. So Congress again changed the law, frankly, to bring it into line with what's the law in most other countries, that if you make a product in country A by a process that's patented in country B, you can't import that product into country B, now the United States. There's a practical problem here. How do you prove how something was made in some factory deep in China? It's not easy. So Congress provided a sort of way out for the U.S. patentee. It said you had to prove that there was a likelihood this was probably done, and you had to make a reasonable effort to find out. But if you still couldn't figure it out, the burdens of proof shifted. Normally, the patentee has to prove infringement, but if it's made abroad, there's a likelihood, and you have been able to find out, because frankly, the person who made it ain't going to tell you. It's now the infringer's job to prove that the patented process was not used. Now let me turn to what I think is probably the third most important thing you need to remember about infringement. It's what you might be able to do to a competitor that you think's infringing your patent. And the other side of the coin is what some patentee might try to do to you. It's a daunting list. Even before trial, you have a potential for injunctions. And after trial, there's a long list of damages that if somebody is found to have infringed, they may have to pay. This what could go wrong is a major reason that, frankly, if you can do it, stay out of litigation. A license may cost you some money, but at least it's certain. First thing on the list was injunctions. What is an injunction? An injunction is basically a court order that says you can't do something. You can't continue to make, use, or sell this product or any product that infringes the patent. That can be absolutely devastating to your business. If you can't make and sell a product that's even a 25% of your entire revenue, you've got troubles. And there's a chance that you can be enjoined from doing this even before a trial. On the other hand, if all your work is for Uncle Sam and the US government, you have a card in your pocket. Congress decided back during World War I that it wasn't going to allow private patent fights to get in the way of what the government needed to do. So it passed a statute that says manufacture, use of things for the government is not infringement. You can only sue the U.S. in the Court of Federal Claims, which is not one of the U.S. district courts, for, quote, reasonable compensation, and you can't get an injunction. For those of you who basically are working for the government, it gives you a nice answer when somebody shows up at your door. Go talk to the government. Leave me alone. But most fights are obviously not between government contractors and patentees. And until fairly recently, only about 12 years ago, if you infringed a valid patent, you were almost always enjoined. There were very few exceptions. My favorite has always been, frankly, the only one I could find when I was teaching, was the City of Milwaukee activated sludge. The court was actually quite sensible. It said, you know, if I enjoin this, I'm going to shut down Milwaukee's sewage system. And all the raw sewage is simply going to have to run into Lake Michigan, and we don't think this is a very good idea. So they refused to grant an injunction. And there were a couple of cases in the medical field where injunctions had also been refused prior to 1906, but they are few and far between. Occasionally, and we'll get back to this in a little more, a court wouldn't grant an injunction to a patentee that itself didn't make or use anything. Such a patentee, you don't have to make and use it yourself to sue, but do I have to give you an injunction if somebody else infringes when you're really not in this market? Well, things changed in 2006. The rule across the board, except in patent cases, were that injunctions didn't automatically issue. Courts had equitable discretion to grant injunctions, and there was a well-established four-part test as to whether you got an injunction. First off, you had to show a reasonable likelihood of success on the merits. Obviously, this is key, particularly before trial. After trial, it's no longer important because the patent has been found valid or invalid. Second, there has to be irreparable harm. We go back one as opposed to forward. And what's irreparable harm? Because this is probably the key factor. Will the patentee be irreparably harmed if no injunction is granted? Or can you frankly solve all of the patentee's reasonable problems by simply giving it money? So since 2006, it's turned to be quite likely that you won't get an injunction before or after trial if the patentee doesn't practice, if he showed he's willing to license other people, or that there would be real harm or disruption in the third-party market. On the other hand, if a patentee is practicing an invention and selling product, probably will get a permanent injunction if there's a loss of market share. Also probably get an injunction if there's a real question whether the the infringer will ever be able to pay royalties or damages. Or frankly, if for some reason the product that the infringer is selling will ruin the patentee's reputation. Okay, so let's suppose maybe an injunction, probably not an injunction, but in any case, there are damages. The statute provides that a court can assess damages. And as a matter of fact, they can assess damages 3 times what they find the actual damages were. It's bad enough to have to pay once, But what about paying 3 times? Somebody's going to have to pay. One question as you go forward is who? You hear a lot about, you deal with companies, why we want corporations to avoid personal liability, et cetera, et cetera. There are cases, particularly for small companies, where there is a single person or a small group of people who really are the company, who really do everything themselves. Courts in those circumstances have made those individuals personally liable, even though they had established a corporate structure. Real company, usual company, probably no personal liability. In a really small one, it may be unlikely, but you can't completely dismiss the potential. So let's take damages kind of a step at a time. Starting off has to be the fact that there's a requirement in the law that if you're selling products, you can't collect damages unless you've marked them so the public has a way of knowing whether this product is patented. You've seen a lot of tags on products. Patented alone doesn't do it. You've got to give the number of the patent. Often there's a long list. In some recent amendments to the law, they say you could use patented if you also had an internet posting that listed all the patents. Really important when this computer you sell may be covered by 15, 20, who knows how many different patents. And you can also put things on the package that a product comes in if it won't go on the product itself. Important thing to remember is that this market requirement is limited to products. If I sell a product that itself is not patented, but is made by a patented process, there is no requirement for me to market. And the public, frankly, has little or no way to really find out unless you put it in your advertising. And a second thing is that even if products are involved, you don't have any protection against damages once you've been told that you're infringing. So, you're an infringer. You've sold a lot of products. How do we determine how much you have to pay? Well, there are the so-called Georgia-Pacific factors, and there are 15 of them, and they frankly go on almost forever. But the two most important, and they go on, frankly, because of what their goal is to try to establish what is a, quote, reasonable royalty rate. The first and last of the factors are probably the most important. If this is a patent that the patentee has licensed, there's an established rate in the license, and that's probably where anybody's going to go. The other is a lot more iffy. It sets up a hypothetical negotiation before anybody's manufactured and asks, what would the patentee and the proposed new manufacturer have agreed to? A lot of guesswork, very hard to reach a conclusion. As a result of which, royalty rates can range, quote, reasonable royalty rates can range all over the face of the map. There used to be a rule of thumb that a royalty rate was going to be about 25% of the infringer's profit, because reasonable royalty by definition assumed that the infringer would be left with some profit, and hopefully enough profit to continue, because that's what the marketplace wants. The Federal Circuit has rejected that in the case of a court decision as to what's a reasonable royalty, but I think it's still a big part of discussions when you try to come up with what should I have to pay you under a license. Typical royalty rates for products range between about 4 and 7%, but they're outliers, and they're particularly in the biotech area, and I've got a couple here. 30% or 29.2, 50% of gross margin, those are big numbers, but they're not really unreasonable when you consider what some of the profits in the drug industry are on each product as it's actually sold, forgetting about all the work that had to be done to develop it in the first place. And when you're asking about a reasonable royalty or thinking about that, don't forget about the royalty base. What percentage of what? 4 to 7% of a computer chip may be reasonable, it may be a little low. 4 to 7% of the entire computer that has the chip in it is probably prohibitive. So what, is there a potential for gaining if you're the patentee, or losing if you're the person on the wrong side of this lawsuit, more than the money necessary to pay a reasonable royalty? The answer is yes. Because a patentee is also permitted, if there's a competitive marketplace, to recover what it would have made if it had made your sales. That can be a very, very big number. It's not based on what the infringer's profits were, but basically what the patent owners might have been. And I've heard various things, and I'll go back to the biomarket, that in the biomarket, the gross profit for an established company with a patented product can be 90+%. The profit for somebody just getting into the business is going to be a lot lower than that. Even in other markets, a patentee is likely to have a far greater profit margin if there's only one seller than it will if there are multiples. And its per unit profit may be more than somebody who wanted to try to get into the market actually sold things for. A lost profit award can be more than an infringer's gross revenues. And let's get for a second back to something that's important, whether we're talking about lost profits or reasonable royalty. On what? A royalty on what? Is it on the start off with? Is it on the entire product sold, the computer, or only the part of it that was really new and the patent should have been limited to, the chip? To make sure that they can collect on something big, patent attorneys usually write patent claims that list not every part, but most of the major parts of the computer. So now the whole computer is patented. They could have written a claim, and maybe deep somewhere in the depths of the patent did, that covered only what was new in the chip. But they wanted to be able to recover for the entire product that was sold. Okay, in addition to that chip or computer, can royalties or profits be recovered on anything else? Answer is yes. You have to look at both what the licensee or the patentee would have sold at the time you sold your product, and also what the patentee would have sold afterward if somebody had bought their product instead of yours. You buy accessories. You buy ink for computer, printers or keyboards or mouses when you buy a computer. You buy ink and paper often when you buy a printer. The patent doesn't cover the ink, it doesn't cover the paper, it doesn't cover the keyboard, it doesn't cover the mouse. But the patentee, if he can show he would have sold those had somebody bought his product, those are included in the royalty base. Also included in the royalty base are probably a lot of the downstream stuff that may have been sold. Particularly, let's look at ink. If I buy an HP printer, I go into the store and HP is more than willing to sell me the ink. Maybe some generic ink, but probably you're going to buy the HP ink. If it's an Epson, you're going to buy a different group of ink. HP would like to recover for all of the lost sales of its ink. It also, in bigger computer situations, just as an example, they're often sold with maintenance contracts. There's a lot of money in maintenance contracts. Patentee would like to recover what it's not getting out of those maintenance contracts also. And it's not at all unusual for a major portion of a patentee's profits and a major portion of the overall selling price, if you're looking at royalties, to be on things that themselves aren't patentable. One other thing you should know, though it probably is usually not particularly important, is you'll remember that a patent application is usually published, usually 2 or 3 years minimum before a patent is actually granted. Suppose you infringe a claim, or would infringe a claim in that application if it had been a claim in a patent. Patentee can recover a royalty for what is sold between when the application was published and the patent is issued, but there are 2 great big ifs, which is why this is probably not particularly important in the real world. First, it doesn't apply unless the final patent claim is for its, quote, same and substantially the same invention as the original application claim that was published, and it usually is the original claim that's published. There's nearly always amendment as you go through there. More often than not, you can't recover because the claims won't be the same. And also, obviously, there's only royalty, and there's some limitations on the period of time, 6 years after the patent is issued. Whereas if you sue more than 6 years after a patent issues, and you often will, because there may not be a real infringer out there for more than 6 years, this doesn't apply, although you can get infringement damages. Last part of damages are what are called enhanced. Willful infringement. The statute says the court could increase the damages up to 3 times what was found. Well, we just went through. Basic damages may be pretty awful. 3 times that is really awful. For a long time, at least 40 years that I can remember, when it came into effect, the Federal Circuit, and before the Federal Circuit came into effect, some of the individual circuits and district courts increased damages if there was what they called willful infringement, which basically could be viewed as, darn it, you knew what you were doing. You knew there was a patent problem, and you went ahead and did it anyway. In 2016, only a couple of years ago, Supreme Court put a minor brake on willful damages and said that typically, you know what, it's really not, typically you don't get them, and frankly, a lot of cases it had turned into being pretty typically that you did when a jury got hold of it. It's limited to things that are really bad, willful, wanton, malicious, bad faith. You're a pirate. Willful infringement is one of the reasons that people have always spent a lot of money on opinions. Supreme Court said that they are no longer specifically required, but people still get them to give themselves a basis for saying that in good faith they thought this patent was not infringed or was invalid. And probably it's not a bad idea to continue getting that type of opinions. Though, as I suggested, and it probably goes all the way back to the first session of this, think about getting an opinion long before you're sued for infringement, because you may get a lot of information that will make it possible for you to go forward in a way that's either less likely to infringe or is less likely to really bother the patentee, and that is more likely, if he is bothered or it is bothered, to end up with a situation in which you can reach some type of rational agreement without going through the litigation process. Last few minutes here, I'd like to change the focus a little. 50 years ago, more than that, in Graham v. Deere, which you'll recall was the Supreme Court's first decision under the 1952 Act, a judge said, and I'm going to quote, that the court had observed a notorious difference between the standards applied by the Patent Office and by the courts. In other words, the courts were finding the Patent Office was issuing a lot of junk, a lot of stuff that shouldn't have been issued. And the view that the Patent Office is not running the type of tight quality control, as the door says, as opposed to control, has not really gone away. So, particularly in 2013, when the American Inventors Act was passed, Congress set up a number of procedures that were intended to make it easier for somebody to challenge an issued patent, and to challenge it in a way that didn't force them to wait for litigation with all of its costs and uncertainties. At the same time, to provide what you would probably call some fair balance, Congress also created some ways in which a patentee, if the patentee knew there was some potential problems with its patent, might try to address them without having to defend them if and when it got to litigation. The review actions really fall into two basic categories: things that a third party can start and things that a patentee can do to strengthen its patent. Let's look at the third party first. The first thing a third party can do is submit prior art documents to the patent office that are potentially relevant to an application it knows about. And how would it know about this application? Probably because it's been published. Most people don't take advantage of this, and I think there are pretty good reasons that they don't. First off, you get to submit the stuff, but unless the patentee or then the applicant specifically responds, you can't do anything else. It's all between these. If the examiner takes your documents and simply tells the applicant that they're relevant and your application is obvious, you don't get to participate in that back and forth. And third parties have a real fear that their documents won't get the light that they should, that they won't be understood the way that they should be, and that unless the examiner has a lot more time to do her job and can really get into this, they won't result in a patent not being granted. And because they were before the patent office, the quote infringer later down the pike who submitted this stuff is going to be faced with, oh, the patent office examiner looked at this and they decided that they didn't make it invalid, which probably means you're going to lose. The other three all deal with things a third party can do after the patent issues. How can they go back to the patent office and in a procedure in which they can take part, get the patent office to take a real look? A couple of sessions ago, I put up a slide on success rates in these types of procedures, and they're pretty high. The patent office figures, as I believe is so on the slide, show that about 75% of challenged claims are held unpatentable. And this is at a cost that also, although it may well run into a few $100,000, is well short of what later litigation will cost. Frankly, the view is that the patent office, at least if you're looking at a complicated case, is much more likely to understand what's really going on and what's really obvious than is a lay judge or jury. And they're also less likely to be swayed by, okay, which lawyer or which expert did I like better? The first procedure is so-called post-grant review. This has to be done pretty quickly after a patent is granted, within 9 months. You have to, if you want to bring it, make it at least a starting showing that at least one claim is likely unpatentable. But you have to show unpatentable why. And you're limited to unpatentable under sections 102, prior art, anticipated, 103, prior art, obvious over the prior art, 112, you've got a lousy specification and claims, they aren't sufficiently definite, the specification doesn't describe enough. What about 101? Patentable subject matter. It's not in the laundry list in the statute. And the extent to which you can raise 101 and how you could raise it, which if you're in realm where you're talking about a patent for a, quote, abstract idea or a law of nature is probably a major offense. How do you bring it in? You might try to bring it in under obviousness, citing a couple of old Supreme Court cases that say the abstract idea or the law of nature should be treated as prior art, whether or not it is. I frankly can't tell you how successful that's going to be. Inter partes review, you can bring it essentially at any time, at more than 9 months after a patent grants. Standards a little higher. It's not likely unpatentable, but you're likely to prevail. And it's more limited. You can only use 102 or 103, and it can only be based on patents or publications. It can't be based on any of the other prior art that's listed in 102. And there's another potential downside for a third party who brings this. Suppose you're not successful. The statutes provide that if you have and you're later sued for infringement, the statutes provide that if you could have brought up something in this post-grant review procedure or this inter partes review, you can't bring it up if you're sued, if you didn't and you're sued for infringement. There's a real estoppel. So what does it mean? It means you have to make, if you're the person who's bringing this, the third party who wants to get this patent out of the way before you make a lot of investment or sell a lot of product, you have to be pretty sure on what grounds you're going to bring it, and pretty sure that those are grounds on which you're likely to win. The third category is the so-called covered business method. And this actually isn't part of the patent 35 U.S.C., the overall patent laws. It's part of what was put in the Inventors Act as a transitional provision to handle patents on what we've called business methods. A lot of the ones the Supreme Court has held invalid. It's limited. You have to be charged with infringement before you can bring it. You have to be, you're limited to 102 and 103. You can do it more than 9 months after patent grant. But this entire provision is going to go away in a little more than a year and a half unless it's extended. And I haven't seen any sign that it's going to be extended. So business methods, which are really 101 issues, the special provision goes away. In query, how much can you do under 101 anyway? But now let's not be afraid of being sued as we close this out, but of what's going to happen if you bring a suit. Suppose you are a patentee and you've got a patent, but darn, it's got problems. For example, you want to take that patent that talks about a firm seat and fixed distance from the ground and sue the maker of the desk chair. You'd be really happy if you could take the word firm out of that claim. And for 2 years after a patent issues, you can try to do that. For 2 years, if you file within 2 years, you can broaden your claims. Even after that period, if there are other problems in the claim, like I don't know what the words in the claim mean, you can try to correct those, but the claim can't get any broader in the process. Reissue has been around for a long, long time and is used fairly regularly, though I think it's probably used less now that you have the potential for re-examination, where you don't have to make the predicate showing that you do for reissue, that all of this came about because we made a mistake when we were after our original patent. You can ask the patent office to re-examine your patent on the basis of new prior art, stuff that wasn't cited that you, quote, didn't know about earlier, but nonetheless could have a bearing on patentability. Why would you want to do this? Patent office can always decide that that new prior art is such that, you know, your patent's invalid. But on the other hand, you're the only person who's really taking part in this procedure. So you may be able to convince them to bless the patent claims, perhaps with some minor amendments. And if that's so, you're putting somebody you sue on these blessed claims at a significant disadvantage when you get to a district court. The final thing that the AIA, Americans Inventor Act, allowed people patent owner to do was so-called supplemental examination. On its face, it's a fairly broad statement to consider or reconsider or correct information that may be relevant and to raise a substantial new question of patentability. That can wrap in a lot of stuff, including all the stuff that can be wrapped into reissue or reexamination. Where it is probably most used is to avoid a downstream claim that you didn't play fair with the patent office. You told them things that weren't quite accurate. You overstated your case. You didn't tell them about prior art you should have told them about. Well, if you can raise all of those in supplemental examination, you can avoid those being issues that a defendant is going to raise when you sue them for infringement later. Well, I've gone a little over an hour here, and we've covered a lot of ground, much too quickly, and I don't doubt that I've left you with a lot of what was he talking about or raised a number of questions. If you have questions, if you need me to be clearer, send the questions in and let me know. I'll try to answer them in the Q&A session about 2 weeks from the time you sit through this. Hopefully, I can answer them in a way that'll help you better understand what you may be facing if you're sued or involved in an infringement action. And they'll also, your questions will help me improve this presentation for the next time that I use it. Thanks. See you in the Q&A. And then for the next session, where we'll talk about exploiting your patent, licensing, partners, etc. Take care.